Answer in the Constitution. Author Manioun, Clarence Call #KF40. Loan 2, ZHC. Interlibrary loan. Ordum. Ill office hours. Friday, 6 p.m. Phone, 2, KF 4000. Cancer in the Constitution. By Clarence E. Manioun, Dean Emeritus, College of Law, University of Notre Dame. Forward. By Charles E. Rice, Professor of Law, University of Notre Dame. Fordham University School of Law Library. Distributed by Young Americans for Freedom, 1221 Massachusetts Avenue, NW, Washington, D.C., 20005. KF 4550. 29M3. 1972. Forward. We are accustomed, said Justice John Marshall Harlan of the Supreme Court in 1964, to speak of the Bill of Rights and the 14th Amendment as the principal guarantees of personal liberty. Yet it would surely be shallow not to recognize that the structure of our political system accounts no less for the free society we have. The structure to which Justice Harlan referred was the federal system, under which governmental powers were divided between the federal government, on the one hand, and the states on the other. The Constitution created a federal government of delegated and enumerated, though flexible, powers. The states retained the governmental powers which had not been delegated. Of course, the states as well as the federal government were bound, though in different ways, by the guarantees of personal liberty written into the Constitution and its amendments. Among these guarantees are the first 8 amendments of the Bill of Rights and the 14th Amendment. The latter, among its other provisions, forbids any state to deprive any person of life, liberty, or property, without due process of law. Originally, the first 8 amendments of the Bill of Rights, including among others, the freedoms of religion, press and speech as well as guarantees of fair criminal procedure, were intended to prohibit only interferences with them by the federal government. The states were unaffected. Then, in 1868 when the 14th Amendment prohibited state denials of due process of law, the states were forbidden to interfere with basic personal liberties, whether or not enumerated in the Bill of Rights. But the states were forbidden to interfere with them only if the liberties infringed upon were so basic as to be implicit in the concept of ordered liberty. Halco v. Connecticut, 302 U.S. 319, 324-25, 1937. The result was a balance between federal and state power, with the states providing a salutary diversity and capacity for experimentation within the framework of basic constitutional rights. Judicial interpretations were characterized by respect for the properly defined independence of the states. This balanced rule of decision was accurately Justice John M. Harlan. The Bill of Rights and the Constitution. Address at the dedication of the Bill of Rights Room, U.S. Sub-Treasury Building, New York City, August 9, 1964. C. Alpheus Thomas Mason. Judicial Restraint and Judicial Duty, An Historic Dichotomy. New York State Bar Journal, June, 1966, 216, 226. Described in Justice Harlan's words, in 1957, that, our function in reviewing state judgments under the 14th Amendment is a narrow one. We do not decide whether the policy of the state is wise, or whether it is based on assumptions scientifically substantiated. We can inquire only whether the state action so subverts the fundamental liberties implicit in the Due Process Clause that it cannot be sustained as a rational exercise of power. The state's power to make printed words criminal is, of course, confined by the 14th Amendment, but only insofar as such power is inconsistent with our concepts of ordered liberty. Roth v. U.S., 354 U.S. 476, 501, 1957. Concurring opinion of Mr. Justice Harlan, citations omitted. This rule of decision served to ensure the balanced division of powers which is essential to a federal system. As K.C. Ware put it, what is necessary for the federal principle is not merely that the general government, like the regional governments, should operate directly upon the people, but, further, that each government should be limited to its own sphere and, within that sphere, should be independent of the other. Where, Federal Government, 1964, 14, C. Kurland, The Supreme Court, Forward, 78 Harvard Law Review 143, 163, 1964. Today, unfortunately, the division of powers has been substantially eroded. Few, if any, areas of state activity remain immune to direct and substantial control by the federal government. More to the point for present purposes, the Supreme Court has rejected the balance achieved by its own long-standing interpretations of the Due Process Clause of the 14th Amendment. That clause has now been interpreted by the Supreme Court to make the first 8 amendments of the Bill of Rights strictly applicable against the states. See, for example, Malloy v. Hogan, 378 U.S. 1, 1964. The states are now bound by the Supreme Court to the same strict standard as the federal government in avoiding infringements on those freedoms. More importantly, those standards are applied with substantial uniformity throughout the nation and the ultimate arbiter for their application is the Supreme Court. All this may seem to be lawyers quibbling, but it is, I hope, more than that. For significant practical consequences are involved. In the field of religion, for instance, the Supreme Court recently invalidated state subsidies given directly to church-related schools. Lemon v. Kurtzman, 39 U.S. Law Week 4835, 1971. In doing so, the court applied the establishment and free exercise of religion clauses of the First Amendment, as interpreted by itself, strictly against the states. It is true that the merits of direct state aid to parochial schools are able. An educational voucher given to the parents, to be used in the school of their choice, would be preferable to direct aid to the schools, but the issue is such that it ought to be removed from the ban of a rigid First Amendment interdict and should be left for resolution, within the framework of due process, to the elected representatives of the people in the states. Subversion, obscenity control, and criminal procedure are some other areas where the Supreme Court has improperly hampered the states by applying the Bill of Rights strictly to them through the 14th Amendment, although the court under Chief Justice Burger has taken a more realistic view of criminal procedure and, to some extent, obscenity control. The unsound interpretations of the Due Process Clause remain effective in principle, and ought to be corrected, if hardening of the constitutional arteries is to be avoided. Greater latitude should be afforded to the states in these and some other areas, provided, of course, that the courts remain entitled to intervene, to restrain violations by the states of the due process of law guaranteed in the 14th Amendment. It would be useful for the Supreme Court, in exercising this function, to follow the principle enunciated by Mr. Justice Robert Jackson in his dissent in a group libel case. In 1952, the history of criminal libel in America convinces me that the 14th Amendment did not incorporate the first, that the powers of Congress and of the states over this subject are not of the same dimensions, and that because Congress probably could not enact this law it does not follow that the states may not. Bourne v. Ill, 343 U.S. 250, 288, 1952. In 1948, Clarence Manioun, then Dean of the Notre Dame Law School, analyzed the changing interpretations of the Due Process Clause in an important and widely quoted article, The Church, the State and Mrs. McCollum, published in the Notre Dame Lawyer. Manioun, The Church, the State and Mrs. McCollum, 23 Notre Dame Lawyer 456, 1948. In that article, Dean Manioun correctly and clearly pointed out the danger latent in the erroneous application of the religion clauses of the First Amendment strictly to the states. This current essay is in the nature of a sequel to Dean Manioun's earlier article, originally prepared at the invitation of the Notre Dame Lawyer, but not published in that journal. It describes the more recent developments of the trends he criticized in the earlier piece. As he makes clear, the errors of the original misinterpretation have been compounded. It is a great pleasure for me to write this introduction, not only because of the importance of the subject but especially because of my high personal regard and professional esteem for Dean Manioun. He brings to his task a long and productive background of constitutional study and exposition as a scholar, teacher, lecturer and public official. Of course, his criticism of the rulings of the Supreme Court will be controversial and his views will not be shared by all. But it must be remembered that criticism of its decisions does not imply disrespect for the court as an institution. Indeed, as in this case, pointed criticism is essential to the proper functioning of the court within our constitutional framework. We are indebted to Dean Manioun for his constructive exposition of a sound alternative to the prevailing interpretations. If the analysis of the Due Process Clause urged by Dean Manioun in his 1948 article had been adopted by the Supreme Court, our problems in the affected areas would be greatly relieved today. Dean Manioun's new presentation deserves the thoughtful consideration of all who are concerned to maintain a balanced and truly federal system of government. Dr. Charles E. Rice, Professor of Law, University of Notre Dame. Like his counterparts in all walks of modern American life, the busy lawyer has lost his perspective. Ruthless necessity is always forcing us to learn more and more about less and less. Immersed in the deep tangled thicket of regulations, rulings, forms and procedures that are ceaselessly burgeoned by the IRS, SEC, FTC, COD, etc., he has lost consciousness of the surrounding forest. As a matter of course, he whips through the advance sheets of decisions that fall like leaves from the appellate courts of his state and, if time permits, he grabs at those that flutter in from the Supreme Court of the United States, but the odds are very long against the chance that he has read 3 consecutive sections of the Constitution of the United States since he left law school. The fate of the Constitution is thus left to the frequently confused judgment of overworked United States Supreme Court justices and to the speculations of professors and students who inhabit what, until recently, were the tranquil groves of academe. This being so, the great body of our legal profession is unconscious of the fact that a poisonous revolutionary mythology is now congealed in and around our federal Constitution. In the absence of the vigilant and vocal professional defenses that have protected the integrity of the Constitution in days gone by, the beguiling pervasive mythology has all but completely subjugated the government of ascertainable law that was created by the Constitution and has established in its place a mercurial generator of last come, first served legislative, executive and judicial decrees that usually waver uncertainly between anarchy and absolutism. The reign of the new mythologized Constitution rolls on unnoticed by all but a few of the American people, for while the great majority of them have always revered the Constitution, less than half of 1% of them have ever paused to read it carefully from beginning to end. In these circumstances, it is ironical to observe that while cancer in the Constitution is rarely read by anybody, it is constantly being cited by practically everybody. A popular mind is thus at work, full-time, making gratuitous constructions and interpretations of the Constitution which are spread like a huge smorgasbord of comforting and appetizing delicacies from which each person may take his pick at will. In this process, constitutional interpretations have become more and more politicized, while the people, the press, the politicians and finally the Supreme Court of the United States are all heard saying strange things about the Constitution which simply aren't so. High Court gets into politics. After the Supreme Court's decision of Downs versus Bidwell was announced in 1901, Peter Finley Dunn, who wrote humorously in the newspapers of that time as Mr. Dooley, commented, "I see now that the Constitution doesn't follow the flag, but I also observe that the Supreme Court follows the election returns." If he were alive today, Mr. Dooley would observe that the Supreme Court no longer follows the election returns. On the contrary, the court now leads and directs them. The judicial hound of Mr. Dooley's day now runs far ahead of the political hare. What the Supreme Court has said and ordered done during the past 17 years makes a greater impact upon the conduct of and the returns from current election campaigns than all of the other factors put together. At this point, any lawyer or law student is free to make his own list of the 6 hottest issues that were debated in all parts of the country prior to the 1968 presidential election. If he does so honestly, he will find that he is able to document at least 4 of them with citations of decisions made by the Supreme Court of the United States during the era of Chief Justice Earl Warren. For openers, start with law and order, and prayer in the schools. Use your own recollections and research for the rest. This politicization of the Supreme Court began in earnest 17 years ago, 1954, when a majority of its justices, and frequently over the strenuous objections of a minority of them, deliberately projected the court into the political arena in order to bring about changes in the social order of the country, changes that, in the court's judgment, had been too long deferred by the inaction of Congress and or the 1. Downs versus Bidwell, 182 U.S. 244, cancer in the Constitution 3. Several state legislatures. In most instances, these changes were unwelcome to the great majority of the American people, which is precisely why our politically sensitized legislatures had refused to establish them. The law for each case becomes the law of the land. The court could and did ignore the unpopularity of its political decrees because, unlike the legislators, it was insulated from popular retribution by the life tenure of the justices. Beyond that, the Supreme Court's political decrees managed to dissolve much of their own popular opposition in the generally prevailing impression that what the Supreme Court pronounces on any subject immediately becomes the supreme law of the land which all good citizens are obliged to respect and obey regardless of their personal likes or dislikes. This popular impression is one of the insidious sophistries sown into the popular mind by the mythologizers. Every lawyer knows, of course, that the Supreme Court's decision in any case that is brought before it does not establish the law of the land but merely the law of the case that it decides, and that the decree made by the court pursuant to its decision binds only the parties before it and nobody else. It is true that the decision of any such case by the Supreme Court gives effective notice to all prospective litigants that future controversies based on substantially the same set of facts and invoking the same legal principles, when and if they are brought before the court, will be decided in the same way unless a sufficient number of the court's justices will have changed their minds in the meantime. But this simple truth is about as far as one can get from the completely false but popular impression that when the Supreme Court of the United States decides, let us say, the case of Jones versus the election commissioners of Illinois in favor of Jones, its decree immediately and ipso facto reaches out to paralyze the power of all of the election commissioners in all states of the Union in exactly the same way. Those who know better now have an urgent obligation to tell all who will listen that the result of the decision in the Jones case does not affect any election commissioner or anybody else in the United States except the commissioners of Illinois who were parties to the Jones case. 2. Jones versus the election commissioners. Of course, the Jones decision would be followed by nationwide agitation through the ACLU, the NAACP, Madeline Murray O'Hare and or other professional litigators to start similar. 4. Cancer in the Constitution. The sophistry that the Supreme Court's decision in the Jones case, or in any other case, establishes the supreme law of the land is one, but only one, of the mischievous popular misconceptions that seed the poisonous mythology now superseding the constitutional government of our country. The Supreme Court now extends the limits of its own jurisdiction. This confusion is worse confounded if the Supreme Court, first, in taking jurisdiction of the Jones case and or second, in reaching its decision in the controversy has resorted to the mythology instead of the Constitution itself for its jurisdiction and justification. A most important example of the first mistake is illustrated in the record of Baker v. Carr decided by the United States Supreme Court in 1962. In this instance, the Supreme Court took jurisdiction of an appeal to it of a case originating in Tennessee in which the plaintiffs, who were qualified voters in that state, claimed a discrimination against themselves resulting from the failure of the Tennessee legislature to reapportion the legislative districts of the state to balance the shifting distribution of the state's population. A 3-judge federal court in Tennessee had dismissed the action on the ground that a political, rather than a legal question, was involved and that the court, therefore, lacked jurisdiction to hear and decide it. From time immemorial, this had been the entrenched position of the Supreme Court of the United States, followed, of course, by all of the inferior federal courts of the country. Nevertheless, the Supreme Court accepted jurisdiction of this appeal, reversed the lower federal court and decided the case in favor of the complainants. For his justification of this turnabout excursion by the court into the politics of Tennessee, Justice Brennan, who authored the official opinion of the court, there were 6 separate and or joint opinions all told, reached for the 14th Amendment which, like a Mother Hubbard pullover, is now used to cover everything while it actually touches nothing that is under consideration. Lawsuits on their way to the Supreme Court with the objective of establishing the enforcement of the Jones Rule everywhere. In the course of this litigation, many inferior court judges would slavishly follow the Jones Rule rather than risk ultimate reversal and its resulting blight upon their judicial record. 3. Baker v. Carr, 369 U.S. 186. Cancer in the Constitution. 5. Justice Frankfurter's farewell warning. Baker v. Carr turned out to be the last Supreme Court case in which the veteran Justice Felix Frankfurter participated, and his extended final opinion, which covers more than 40 printed pages, is a bitter, prophetic dissent in which Justice Harlan concurred. Here are some samples of what Justice Frankfurter wrote about the mythological justification for the Supreme Court's interference with the district and of state legislatures. The court today reverses a uniform course of decision established by a dozen cases, including one by which the very claim now sustained was unanimously rejected only 5 years ago. Such a massive repudiation of the experience of our whole past in asserting destructively novel judicial power demands a detailed analysis of the role of this court in our constitutional scheme. It may well impair the court's position as the ultimate organ of the Constitution. Appellants seek to distinguish several of this court's prior decisions on one or another ground. Suffice it to say that they do not serve to distinguish. Kidd v. McCandless, in which the full court without dissent, only 5 years ago, dismissed on the authority of Colgrove v. Greens and Anderson v. Jordan an appeal from the Supreme Court of Tennessee in which a precisely similar attack was made upon the very statute now challenged. In effect, today's decision empowers the courts of the country to devise what should constitute the proper composition of the legislature of the 50 states. In this situation as in others of like nature, appeal for relief does not belong here. Appeal must be to an informed, civically militant electorate. In a democratic society like ours, relief must come through an aroused popular conscience that sears the conscience of the people's representatives. Justice Frankfurter quoted from Mr. Justice Woodbury's opinion in the basic case of Luther v. Borden. 4. Kidd v. McCandless, 352 U.S. 920, S. Colgrove v. Green, 328 U.S. 549, 6. Anderson v. Jordan, 343 U.S. 912, 7. Luther v. Borden, 7 Howard 51-53, 1849. 6. Cancer in the Constitution. If the people in the distribution of powers under the Constitution should ever think of making judges supreme arbiters in political controversies, when not selected by nor frequently amenable to the people, they, the people, will dethrone themselves and lose one of their own invaluable birthrights, building up in this way, slowly but surely, a new sovereign power in the Republic in most respects irresponsible and unchangeable for life, and one more dangerous than the worst elective oligarchy in the worst of times. After a majority of the Warren Court judges departed from the unbroken and indisputable line of precedent and argument set forth by Justice Frankfurter, to accept jurisdiction of the appeal in Baker v. Carr, they were unable to agree on reasons why the decision of the lower court should be reversed. Their several opinions on that point make a discordant symphony of distinctions and mutual contradictions. Nevertheless, the majority did come together in its determination to cross the Rubicon into the political thicket of legislative reapportionment. The big cat was now out of the bag. Federal judges now police and enforce their own decrees. Previously, federal courts had consistently refused to use their equity powers of injunction in cases involving political issues arising from a state's geographical distribution of electoral strength among its political subdivisions. 8. In other words, federal courts with Supreme Court approval had refused to be used as an instrument to enforce what has come to be called the one Manioun vote formula. After Baker v. Carr, this important feature of the court's historic judicial restraint went out the window. Soon, federal judges in a dozen states of the Union activating what they each interpreted to be Supreme Court mandates, were devising formulas for redistricting the legislatures of each of these states and threatening injunctions against the future election of legislators unless their judge-made formulas for reapportionment were established in the meantime. In 1964, the Supreme Court extended its new one Manioun vote rule into the formation of the state's congressional districts. This 8. South et al. Versus Peters, 339 U.S., 276-9. Wesbury versus Sanders, 376 U.S. 1. Cancer in the Constitution 7. Constituted a joint affront to the express constitutional powers of Congress and of each state in which the congressional districting was questioned. Article I, Section 4 of the Constitution stipulates that the times, places and manner of elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. This provision makes it very plain that all features of congressional elections are legislative questions to be settled by the political arms of the state and federal government respectively. The state legislature is given the first go at making these arrangements. If, in the judgment of Congress, there is something wrong with any of these state provisions and regulations, Congress may alter them in any respect or proceed to supplant all of the state's regulations with regulations of its own. There is no room in this constitutional provision for any intervention by the courts on any pretext, so the Warren Justice is convenient. Lee ignored the precise constitutional directive and went back to the cupboard of Old Mother Hubbard for its all-encompassing mythology of the 14th Amendment. Frankfurter had departed from the court when the congressional districting case was considered, 1964, and so it remained for Justice Harlan to remind the court of what its apportionment decisions were doing to the court and to the country. What the court has done today, said Harlan, has the effect of placing the basic aspects of state political systems under the pervasive overlordship of the federal judiciary. The 14th Amendment does not impose this political, one Manioun vote, tenet on the states or authorize this court to do so, bringing legislative apportionments within the purview of. The 14th Amendment amounts to nothing less than an exercise of the amending powers by this court. Only one who has an overbearing impatience with the federal system and its political processes will believe that this price was not too high, or was inevitable. The taproot of the constitutional malignancy that we have called the mythology is the 14th Amendment. Without the 14th Amendment, the mythologizers would have found no footing for the controlling judicial superintendents which they have built into the Constitution during the past 17 years. But why did they wait, 8 cancer in the Constitution so long to tap this rich source of constitutional heresy? After all, the 14th Amendment has been a part of the Constitution for 103 years, or has it really? Serious questions involving the proposal and ratification of the 14th Amendment have persisted without an official determination ever since July 21, 1868. That was the day Congress declared the amendment to be a part of the Constitution and directed Secretary of State Seward to promulgate it as such. The day before this congressional resolution was passed, July 20, 1868, the Secretary of State had publicly announced his own official misgivings about the regularity and finality of the amendment's ratification. One of his doubts had arisen when Ohio and New Jersey, both having been previously counted for their respective ratifications, officially withdrew their earlier assent to the amendment. However, when Congress issued its peremptory and unprecedented command, Seward quickly complied and came through with the official promulgation on July 28, 1868. From that day to this, the heavy shadow of a bar sinister has hung over the heraldry of the 14th Amendment. The shadow is a reflection of the turmoil of congressional presidential conflicts and contradictions out of which the amendment tortuously emerged. Was the 14th Amendment legally ratified? The Supreme Court declines to answer. It is significant, if not surprising, to note that the Supreme Court of the United States, which in recent years has used the amendment regularly as a springing board to vault itself into the political arena, refused in 1939 to pass upon the validity of the amendment's ratification because in the court's judgment, that was a political question, the determination of which is vested exclusively in Congress. In conceding that this was a matter for congressional determination, the opinion recited these facts. The legislatures of Georgia, North Carolina and South Carolina had rejected the amendment in November and December, 1866. New governments were erected in those states, and in others, under the direction of Congress. The new legislatures ratified the amendment, that of North Carolina on July 4, 1868, that of South Carolina on July 9, 1868 and that of Georgia on July 12, 1868. 1010. Coleman versus Miller, 307 U.S. 433. Legits 1 equals. So a T.C. C. He. A. S. Why? Cancer in the Constitution 9. What the court did not mention was the fact that the southern state legislatures which Congress put out of existence as unlawful with its Reconstruction Act of 1867, had nevertheless been recognized as lawful for the purpose of ratifying the 13th Amendment which Congress had proposed on February 1, 1865, and which was designed solely to abolish slavery. The final ratification of the 13th Amendment was accomplished on December 6, 1865, by the ratification of the amendment by the legislature of the 27th state, Georgia. On December 18, 1865, Secretary of State Seward publicly certified that the 13th Amendment had become a part of the Constitution since legislatures in 3/4 of the 36 states, then in the Union, had ratified it. Without its ratification by the legislature of Georgia, South Carolina, North Carolina and other southern states respectively, the required ratification of the 13th Amendment by 3/4 of the states could not have been obtained. The new southern state legislatures which Congress instituted through the Reconstruction Act, 1867, and which dutifully ratified the 14th Amendment as the Supreme Court observed, supra, did not re-ratify the 13th Amendment. President Lincoln had conducted and won the Civil War on the theory that the so-called Confederate states could not legally secede from the Union, and since he had made his point by military victory, the ex-Confederate southern states, never having been out of the Union, promptly proceeded to ratify the 13th Amendment as we have just noted. 11. We may have a 13th or a 14th Amendment underscore take your choice. So it came to pass that the states that could not get out of the Union in the first place, and which had ratified the 13th Amendment as members of the Union in the second place, were now nevertheless reorganized and readmitted to the Union by Congress in the third place, having performed under duress the prescribed condition preche. 11. In his first inaugural, Lincoln said, "It is safe to assert that no government proper ever had a provision in its organic law for its own termination. No state, upon its own mere motion, can lawfully get out of the Union, that resolves and ordinances to that effect are legally void." McPherson's Political History, page 106. 10. Cancer in the Constitution. Dent to readmission, namely, the ratification of the 14th Amendment which the South and President Andrew Johnson had so bitterly opposed. All this being so, a few collateral, although perhaps purely academic, questions are raised. For instance, does the Constitution of the United States really contain a 13th Amendment? If it does, just when and by what valid state legislatures was it ratified? If the 13th Amendment was validly ratified, then the Southern state legislatures, whose ratifications were counted in order to make it so, were likewise legitimate. But if this is the case, then the summary dethronement of those valid legislatures by Congress would seem to be invalid, and so also would be the new Southern legislatures which Congress immediately installed. Yet, if the ratifications by those invalid congressionally created Southern legislatures is subtracted from the total of ratifications which the 14th Amendment received, then that amendment has never been ratified by the legislatures of 3/4 of the several states that Article V of the Constitution requires. So which amendment shall we retain, the 13th or the 14th? Or can we have it both ways? In any event, the logic of the Warren Court's mythologizers would seem to be on a collision course with either one or the other of these amendments. Perhaps the justices should fasten their seatbelts while they decide which way to turn. The original 14th Amendment, its bark was worse than its bite. In spite of the widespread rancor, recriminations and apprehensions that the proposal of its drastic provisions produced in the North as well as throughout the South, the 14th Amendment made little or no impact upon the habit patterns of the American people or upon the self-government of the several states of the Union during the first half-century following its official recognition as a part of the Constitution. By the direction of the amendment's fifth and final paragraph, the enforcement of its punishing provisions by appropriate legislation was given to the Congress, and the angry anti-Southern controlling majority of that body in 1868 caused the ex-Confederate population of the country to fear the worst. Ironically, the Supreme Court of the United States, which now uses the 14th Amendment as the predicate of all of its forays into TSP Pick. Cancer in the Constitution. 11. The constitutional domain of Congress and of the several states respectively, was the chief instrument for the containment and tight restriction of the amendment's ominous potential 100 years ago. People in the South were particularly apprehensive about the use that Congress might make of the Privileges and Immunities Clause to centralize control of all civil rights in the hands of the federal government. Historically and constitutionally, this control was in the hands of the several states, but anti-Southern politicians strenuously waving the bloody shirt of the Civil War were making no secret of their plans to change the location of those controls peremptorily. It so happened, however, that the Privileges and Immunities Clause of the amendment was unexpectedly reduced to a nullity for practical purposes by a bare majority of the Supreme Court in its decision of the slaughterhouse cases in 1873.12. The majority construction of what this clause of the amendment was intended to do undoubtedly surprised and angered the radical anti-Southern members of Congress, who had expected that the 14th Amendment would effectively establish complete congressional control over the people and the politics of the conquered Southern states. Whoever reads all of the 5 paragraphs of the 14th Amendment carefully will find the substance of this expectation, as well as the reason for the bitter resistance that the proposal for the amendment's ratification encountered in the Southern state legislatures before they were reorganized by the Congressional Reconstruction Act. Congress passes the first Civil Rights Acts. In 1866, after the 13th Amendment had been ratified, December 6, 1865, Congress passed its first Civil Rights Act, relying on the new 13th Amendment for its validity. The short and simple language of this amendment was a very slender thread upon which to hang the sweeping investiture of voting rights and other privileges and immunities that the act conferred upon all citizens regardless of race, color, or previous condition of servitude. Congress recognized this, and in 1870, following the official ratification of the 14th Amendment, July 28, 1868, and confidently relying upon its new constitutional authority, Congress repassed much of the 1866 Act, reinforcing 12. Slaughterhouse cases, 16 Wall 36. 12. Cancer in the Constitution, the civil rights enumerated in that statute. Then came the Supreme Court's decision of slaughterhouse cases, April 14, 1873, with its analysis of what the original Constitution and now the 14th Amendment comprehend by references to the privileges and immunities of citizens of the United States. 13. Said Justice Miller for the majority. Beyond the very few express limitations which the federal Constitution imposed upon the states, such for instance, as the prohibition against ex post facto laws, bills of attainder and laws impairing the obligation of contracts, and a few other restrictions, the entire domain of the privileges and immunities of citizens of the states, as above defined, lay within the constitutional power and legislative power of the states, and, outside that, the constitutional and legislative power of the federal government. Was it the purpose of the 14th Amendment, by the simple declaration that no state should make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, to transfer the security and protection of all the civil rights which we have mentioned from the states to the federal government? And where it is declared that Congress shall have the power to enforce that article, was it intended to bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the states? Such a construction would constitute this court as a perpetual censor upon all legislation of the states on the civil rights of their own citizens, with authority to nullify such as it did not approve as consistent with those rights, as they existed at the time of the adoption of this amendment. We are convinced that no such results were intended by the Congress which proposed these amendments, nor by the legislatures of the states which ratified them. Ibid, coming as it did at this particularly troubled time in our post-Civil War history, this was a bold stop sign for the court to hold up in the face of a Congress, many of whose members were eager to reap a rich political harvest by the immediate wholesale enfranchisement of the thousands of Negroes recently freed from slavery. 13. Article 4, Section 2, Number 1. United States Constitution. Cancer in the Constitution 13. Congress controls appellate jurisdiction of Supreme Court. In 1869, the court had been rudely reminded that all of its appellate jurisdiction is held at the pleasure of Congress. 14 At that time, the Supreme Court had agreed to hear an appeal in a petition for a writ of habeas corpus by one McArdle, a Mississippi newspaper editor, who was being held in custody by the United States military authorities under the authority of the Congressional Reconstruction Acts. McArdle's petition challenged the constitutionality of these statutes. The Supreme Court heard the arguments in the McArdle case on the merits and took it under advisement. 15 Meanwhile, Congress became alarmed and fearful of a. Test of the Reconstruction Acts, enacted a statute withdrawing appellate jurisdiction from the court in certain described habeas corpus proceedings which comprehended the McArdle appeal. 16 The Supreme Court then proceeded to dismiss the appeal for want of jurisdiction. Said Chief Justice Chase, without jurisdiction, the court cannot proceed at all in any cause. Jurisdiction is the power to declare the law, and when jurisdiction, ceases to exist, the only function remaining to the court is that of announcing the fact and dismissing the cause. Judicial duty is not less fitly performed by declining ungranted jurisdiction than in exercising firmly that which the Constitution and the laws confer. 17 In the years since its enactment of the first Federal Judiciary Act in 1789, and for a variety of reasons, Congress had frequently employed its express, unquestioned constitutional power over the jurisdiction of all federal courts. 18 Its political motivation in the McArdle. 14. Article 3, Section 2, United States Constitution. 15. Ex parte McArdle, 6 Wall 318, 1868, 16. 15 Stat 44, 1868 17. 7 Wall 506 to 14, 1869 18. The result of the McArdle case goes to the ultimate in sustaining congressional power over the court's appellate jurisdiction, and it has been frequently affirmed and approved. The result is to vest an unrestrained discretion in Congress to curtail and even abolish the appellate jurisdiction of the Supreme Court and to prescribe the manner and forms in which it may be exercised. The Francis Wright, 105 U.S. 381, 1882, Ex parte Urger, 8 Wall 85, 1869, Kurtz v. Moffin, 115 U.S. 487, 1885, Cross v. Burke, 146 U.S. 82, 1892, Missouri v. Pacific Railway Company, 292 U.S. 13, 1934, Stephan v. U.S., 319 U.S., 423, 1943, see also U.S. v. Burry, 208 U.S., 393, 1908, where it was held that there is no right to appeal to the Supreme Court except as an act of Congress confers it. The Constitution of the United States of America, analysis. 14 Cancer in the Constitution. Matter was obvious but completely irrelevant. Congress can do as it pleases to do with the appellate jurisdiction of the United States Supreme Court. In its 1873 mood, it might conceivably have stripped the Supreme Court of its jurisdiction to hear any appeals involving the 14th Amendment. Justice Miller was undoubtedly conscious of that possibility when he wrote the majority opinion in the Slaughterhouse cases, supra. This consciousness is implicit in the dissenting opinions in those cases by Chief Justice Chase, Sick, and 4 other justices. But while the criticism on Capitol Hill was plentiful, Congress took no official action against the court's jurisdiction as it had in the appeal of McArdle. 1873 to 1883-1906. The Supreme Court declares that congressional civil rights acts are unconstitutional in 1883, 10 years after its decision of the Slaughterhouse cases. The post-war Congressional Civil Rights Acts came before the Supreme Court for an across-the-board final determination. 19 Question. Did its stipulated power to enforce the 13th and or the 14th Amendment authorize the Congress, without any reference by it to ad and interpretation prepared by the Legislative Reference Service, Library of Congress, 1952 and 1964 edition, Edward S. Corwin, editor, 1952, and Norman J. Small, editor, 1964, page 700, Congress has repeatedly exercised its power to limit the use of injunction in the federal courts. The first limitation on the equity jurisdiction of the federal courts is to be found in Section 16 of the Judiciary Act of 1789, which provided that no equity suit should be maintained where there was a full and adequate remedy at law. The Act of March 2, 1793, prohibited the use of any injunction by any court of the United States to stay proceedings in state courts except where such injunctions may be authorized by any law relating to bankruptcy proceedings. In subsequent statutes, Congress has prohibited the issuance of injunctions in the federal courts to restrain the collection of taxes. 14 Stat 475, 1867, provided for a 3-judge court, as a prerequisite to the issuance of injunctions to restrain the enforcement of state statutes for unconstitutionality. 36 Stat 557, 1910, and for enjoining orders of the Interstate Commerce Commission. 38 State 220. 1913, limited the payer issue restraining fate orders of state public utility commissions. 48 Stat 775, 1934, and the use of injunctions in labor disputes. Clayton Act, 1914 and Norris LaGuardia Act, 1932. The Constitution of the United States of America, analysis and interpretation prepared by the Legisla. Live Reference Service, Library of Congress, 1952 edition, Edward S. Corwin, editor, page 523. 19. Specifically in question was the Climactic Civil Rights Act passed by Congress March 1, 1875, entitled An Act to Protect All Citizens in Their Civil and Legal Rights, 18 Stat 335, f. 1. 1. Cancer in the Constitution 15. Verse state legislation on the subject, to impose a penalty upon an individual who denied to any citizen because of race, color or previous condition of servitude, equal treatment in a variety of transactions described by Congress in the Civil Rights Acts, such as equal accommodation in inns, public conveyances, places of amusement, etc. The Supreme Court's answer, an unequivocal no. The court held that the attempt by Congress to do that is not authorized by either the 13th or the 14th Amendments. Said Justice Bradley for the court, the amendments, 13 and 14, are different and the powers of Congress under them are different. What Congress has power to do under one, it may not have power to do under the other. Under the 13th Amendment, the power has only to do with slavery and its incidents. Under the 14th Amendment, it has power to counteract and render nugatory all state laws and proceedings which have the effect to abridge any of the privileges or immunities of citizens of the United States, or to deprive them of life, liberty or property without due process of law, or to deny to any of them the equal protection of the laws. Under the 13th, the congressional legislation so far as necessary or proper to eradicate all forms and incidents of slavery and involuntary servitude, may be direct and primary, operating upon the acts of individuals whether sanctioned by state legislation or not. Under the 14th, as we have already shown, it must necessarily be, and can only be, corrective in its character, addressed to counteract and afford relief against stage regulations or proceedings. The 13th Amendment has respect, not to distinctions of race or class or color but to slavery. It would be running the slavery argument into the ground to make it apply to every act of discrimination which a person may see fit to make as to the guests he will entertain, or as to the people he will take into his coach or cab or car, or admit to his concert or theater or deal with in other matters of intercourse or business. When a man has emerged from slavery, and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen, or a man, are to 16 Cancer in the Constitution. Be protected in the ordinary modes by which other men's rights are protected. No countenance of authority for the passage of the law in question can be found in either the 13th or 14th Amendments of the Constitution, and no other ground of authority for its passage being suggested, it must necessarily be declared void, at least as far as its operation in the several states is concerned. 20 After the Supreme Court's narrow and constricting constructions of it, 1873, in the slaughterhouse cases, and later, 1883, in the civil rights cases, 22 Congress abandoned its attempts to enforce the 13th or 14th Amendments by primary legislation aimed at the conduct of individual citizens in their dealings with Negroes. Thereafter, the sweeping protections that it had staked out for black citizens in the Civil Rights Acts of 1866, 1870 and 1875 were left to sleep quietly, unenforced, in the federal statute books. Rare sporadic attempts by litigants to reactivate these laws were usually smothered in the courts of first resort. In 1906, one of these cases finally reached the Supreme Court. 23 The appeal was from an indictment of Arkansas citizens who allegedly violated certain sections of the dormant Civil Rights Acts by a conspiracy to prevent citizens of the United States of African descent from the orderly pursuit of their private employment solely because they were Negroes. Justice Brewer delivered the opinion of the court. After reading the 13th Amendment into his opinion, he said, "The meaning is as clear as language can make it. The things denounced are slavery and involuntary servitude, and Congress is given power to enforce that denunciation. All understood by these terms a condition of enforced compulsory service of one to another. While the inciting cause of the 13th Amendment was the emancipation of the colored race, yet it, the amendment, is not an attempt to commit that race to the care of the nation. It is the denunciation of a condition and not a declaration in favor of a particular people. It reaches every race and every individual thereof. Slavery or involuntary servitude of the Chinese, of the Italian or 20. Civil rights cases, 109 U.S. 3, 21. Slaughterhouse cases, 21 Law ed. 394, 22. Civil rights cases, 109 U.S. 3, 23. Hodges vs. United States, 27 SC, 6. D. Cancer in the Constitution 17. Of the Anglo-Saxon are as much within its compass as slavery or involuntary servitude of the African. It is said, however, that one of the disabilities of slavery, one of the indicia of its existence was a lack of power to make or perform contracts, and that when these defendants compelled the colored men named to desist from performing their contract, they, to that extent, reduce those parties to a condition of slavery. But every wrong done to an individual by another operates, pro tanto, to abridge some of the freedom to which the individual is entitled. A free man is entitled to be protected in his person from assault and battery. He is entitled to hold his property safe from trespass or appropriation, but no mere assault or trespass or appropriation operates to reduce the individual to a condition of slavery. 99 Near the end of his opinion, Justice Brewer added one thing more. At the close of the Civil War, when the problem of the emancipated slaves was before the nation, it, the nation, might have left them in a condition of alienage or established them as wards of the government like the Indian tribes, and thus retain for the nation jurisdiction over them, or it might, as it did, give them citizenship. It chose the latter. By the 14th Amendment, it made citizens of all born within the limits of the United States and subject to its jurisdiction. By the 15th Amendment, it prohibited any state from denying the right of suffrage on account of race, color, or previous condition of servitude. And by the 13th, it forbade slavery or involuntary servitude anywhere within the limits of the land. It is for us to accept the decision, which declined to make them wards of the nation or leave them in a condition of alienage where they would be subject to the jurisdiction of Congress, but, on the contrary, gave them citizenship, doubtless believing that thereby, in the long run, their best interest would be subserved, they taking their chances with other citizens in the states where they should make their homes. For this reason, we believe that the United States court had no jurisdiction over the wrong charged in the indictment. It followed, therefore, from what Justice Brewer had said and from what the court held in this case, Hodges vs. United States, that Congress cannot make it an offense against the United States for individuals by themselves or in concert or combination with others, even by 18 Cancer in the Constitution, force, to prevent citizens of African descent from entering into or fulfilling their contracts, even when the contracts have to do with earning their livelihood. 24 By this time, 1906, through one case after another, the Supreme Court had formulated, firmed up and copper-riveted two conclusions about the 13th and 14th Amendments respectively. The first conclusion was this. A. The responsibility of Congress for enforcing the 13th Amendment gave it no power to prevent, redress or punish wrongs committed by individual citizens against Negroes because of their race, color or previous condition or servitude, unless the wrong resulted in the enslavement of a Negro or some other person. The second conclusion was, B. The responsibility of Congress for the enforcement of the 14th Amendment arises only when a state by its laws or other official state actions has abridged the privileges or immunities of citizens of the United States, as narrowly defined in the slaughterhouse cases 2, or had deprived any person of life, liberty or property without due process of law, or had denied to any person within its jurisdiction the equal protection of the laws. When and if any such state action takes place, Congress is authorized, by the 14th Amendment, to pass corrective legislation. The extensive powers of Congress to enforce the second, third and fourth paragraphs of the 14th Amendment had never been brought before the Supreme Court for construction because no congressional attempt to enforce them had been made when Hodges was 24. However, at this point, you must observe that on June 17, 1968, Jones v. Alfred Meyer, 392 U.S. 409, the Supreme Court vaulted over Hodges v. United States all the way back to the defunct Civil Rights Act of 1966 to conclude that the fact that the statute lay dormant for many years cannot be held to diminish its force today and held that the authority of Congress to enforce the 13th Amendment includes power to eliminate racial barriers to the acquisition of real and personal property. As one of the disabilities of slavery, perhaps, see Hodges, supra. Or would this be running the slavery argument into the ground? Civil rights cases, supra. Justice Stewart, who wrote the Court's opinion, didn't say. See also Sullivan v. Little Huntington Park, 90. SC 400, December 15, 1969. 25. Slaughterhouse cases, 21 Law ed. 394. Of, if. De Inzi, Inde. 8. 1 de Try. Cancer in the Constitution 19. Decided, 1906, nor has any such attempt been made since. 26 For practical purposes, therefore, the ultimate enforcement of the 13th and 14th Amendments has been confined to those specific situations described in cases and controversies that have been appealed to the Supreme Court of the United States from decisions rendered by the state courts and lower federal courts of the country. By this tortuous method of inclusion and exclusion in its judgments and decisions in thousands of such appeals, the Supreme Court gradually ground out working definitions of what the 14th Amendment means by its references respectively to life, liberty, property, due process of law and equal protection of the laws, which the several state governments are required by the amendment to respect. The large part of our important judicially determined constitutional law as it exists today consists of conclusions drawn from these court constructions of the 14th Amendment. 26. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion, or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens. 21 years of age in such state. United States Constitution, Amendment 14, Sec. 2. No person shall be a senator or representative in Congress, or elector of President and Vice President, or hold any office, civil or military, under the United States, or under any state who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may by a vote of 2/3 of each house, remove such disability. United States Constitution, Amendment K4, Sec. 3. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slaves, but all such debts, obligations, and claims shall be held illegal and void. United States Constitution, Amendment 14, Sec. 4. The right to remove disabilities imposed by Section 3 of Amendment 14 was exercised by Congress at different times at behalf of enumerated individuals. December 14, 1869, 16 Stat 607, 1872, 17 Stat 142, 1898, 30 Stat 432. 20 Cancer in the Constitution. What happened to the 9th and 10th Amendments? The rank growth of this 14th Amendment law in recent years has made a dead letter of the 10th Amendment, which was the final climactic article of the Bill of Rights put into the Constitution along with the other 9 articles by the ratification of Virginia, December 15, 1791.27. The 10th Amendment, like the 9th, was a posi tive rule for the subsequent construction of the Constitution by Congress and the courts. They were added to the Bill of Rights to quiet the general fear of the people that these federal instrumentalities would otherwise usurp the powers of the states and the rights of the people of the states that were reserved to the states respectively and retained by their people after the adoption of the Constitution. History has demonstrated that the popular apprehensions which demanded the inclusion of Amendments 9 and 10 were completely justified. For all practical purposes, these amendments have been ignored by the federal courts. 28 In the early years of the Republic, the 10th Amendment was frequently advanced in court cases as a restriction upon the exercise of certain powers by Congress but never successfully. Chief Justice Marshall dealt the 10th Amendment a body blow in his decision of McCulloch v. Maryland in 1819.29. It was revived in 1870 when Justice Nelson immunized the salaries of state officers from the imposition of a federal income tax in this rousing restatement of the states' rights doctrine. 27. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. United States Constitution, Amendment 9. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. United States Constitution, Amendment 10. 28. There has been no direct judicial construction of the Ninth Amendment by the Supreme Court of the United States. There are very few cases in the inferior courts in which any attempt has been made to use the Ninth Amendment as the basis for the assertion of a right, but in each of these cases, it has been held that the amendment was not applicable. The Forgotten Ninth Amendment by Bennett B. Patterson, Bobbs Merrill, page 27. The Declaration of Natural Rights in the Ninth Amendment is not something to be relegated to a lumber room of outworn juristic of political ideas. The task is rather to make the natural law and natural rights as believed in by the founders of our polity-flective political and legal instruments in the society of today. Roscoe Pound quoted F. Illibid, 29. McCulloch v. Maryland, 4 Wheaton 316. Cancer in the Constitution 21. The general government and the states, although both exist within the same territorial limits, are separate and distinct sovereignties, acting separately and independently of each other within their respective spheres. The former in its appropriate sphere is supreme, but the states within the limits of their powers not granted, or in the language of the 10th Amendment reserved, are as independent of the general government as that government within its sphere is independent of the states. 130. Undoubtedly, this is exactly what the framers of the 10th Amendment meant when they added it to the Constitution. While Collectorus Day was expressly overruled in 1939 when the Supreme Court made the salaries of federal officers subject to state income taxes, and vice versa, there was no attempt by the court then to diminish the sweeping interpretation of the 10th Amendment as Justice Nelson had intoned it. 31. The slow growth of 14th Amendment law. You will observe that the 14th Amendment had been declared to be a part of the Constitution in 1868 and that Justice Nelson had all of its restrictions upon state power before him when he made this construction of the 10th Amendment in 1871. This is additional evidence that the metamorphic importance of the Civil War amendments to constitutional construction was much less obvious to the generation that put them into the Constitution than it is now to our own. The volume of 14th Amendment law that was developed by the Supreme Court during the first 50 years of the amendment's history, supra page 18, was, in the main, both conservative and consistent and for that reason, generally predictable by trial judges, state legislatures and practicing lawyers. In sum, it severely diminished the length and breadth of historic state power, but that was to be expected from the express language of the amendment itself. Nevertheless, the Supreme Court had consistently held that the restrictions holding state actions to due process and equal protection were not designed to interfere with the reasonable exercise of the police power of each state to provide regulations to promote the health, peace, morals, education and good order of the people. As early as 1878, the Collector vs. Day, 11 Wall 113, 31. Graves vs. New York ex rel. Keefe, 306 U.S. 466, 22. Cancer in the Constitution Court announced that in determining what was reasonable and therefore permitted, as distinguished from unreasonable and therefore violation of the amendment, the intent and application of its restrictions would be ascertained by the gradual process of judicial inclusion and exclusion as the cases presented for decision shall require. 92. This flexible, broad-gauge judicial license for the continuation of reasonable state regulations and classifications in spite of 14th Amendment requirements of due process and equal protection respectively worked its way safely through a long succession of Supreme Court decisions pro and con and often over strenuous dissenting opinions, but by 1920, it had become the basic accepted principle of 14th Amendment law. The movement to merge the Bill of Rights with the 14th Amendment in determining, case by case, the meaning of liberty, property and due process of law, the court drew upon the accumulated experience of history going all the way back to Magna Carta. During the early years of this construction period, the justices could and did have reference to their own personal recollection of the purposes of the members of Congress who had framed the amendment and ordered its ratification by the states. 33. They had promptly rejected the contention that in the interpreting the meaning of life, liberty, property, and due process of law as these terms were used in the 14th Amendment, there was any positive or directive help to be had by references to the 5th article of the Bill of Rights where the same words plus many others are used to restrict the legislative powers of Congress. 34. In 1884, the Supreme Court used the language of the 32. Davidson vs. New Orleans, 96 U.S. 103-4, 1878, 33. See notes 20 and 21 supra. 34. No person shall be held to answer for a capital, or otherwise infamous crime, unless on a. presentment or indictment by a. grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in line of war or public danger. Ref. Shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled ibery criminal case to be a. witness against himself, nor be deprived of life, liberty, in property, without dueness as of law, nor shall private property be taken of public use, without precise compensation. United States Constitution, Amendment 5. Cancer in the Constitution 23. Fifth Amendment itself, to prove that the framers of the 14th Amendment could not have intended it to absorb all of the provisions of the Fifth Amendment and thus certainly they did not intend it to absorb all of the restrictions that the first 8 amendments had imposed upon Congress. 35. The controlling conclusion of Twining vs. New Jersey. The persisting contention that the 14th Amendment was intended to include all of the provisions of the first 8 amendments was rejected and laid to rest with unequivocal logic, if not actual finality, in Twining vs. New Jersey, 1908. After eliminating one article of the Bill of Rights after another from any possible identification with the 14th Amendment and citing the Supreme Court decisions supporting each elimination, Justice Moody concluded, it is possible that some of the personal rights safeguarded by the first 8 amendments against national action may also be safeguarded against state action because a denial of them would be a. denial of due process of law. If this is so, it is not because those rights are enumerated in the first 8 amendments, but because they are of such a. nature. 35. According to a recognized canon of interpretation especially applicable to formal and solemn instruments of constitutional law, we are forbidden to assume, without clear reason to the contrary, that any part of this important amendment, 5, is superfluous. The natural and obvious inference is that, in the sense of the Constitution, due process of law was not meant to include, by its own terms, the institution and procedure of a grand jury in any case. The conclusion is equally irresistible that when the same phrase was employed in the 14th Amendment to restrain the action of the states it was used in the same sense and with no greater extent, and that if in the adoption of that amendment it had been part of its purpose to perpetuate the institution of the grand jury in all the states, it would have employed, as did the Fifth Amendment, express declarations to that effect. Due process of law in the latter, Fifth Amendment, refers to that law of the land which derives its authority from the legislative powers conferred upon Congress by the Constitution of the United States, exercised within the limits therein prescribed and interpreted according to the principles of the common law. In the 14th Amendment by parity of reason, it refers to that law of the land in each state which derives its authority from the inherent and reserved powers of the state exerted within the limits of those fundamental principles of liberty and justice which lie at the base of all our civil and political institutions and the greatest security for which resides in the right of the people to make their own laws, and alter them at their pleasure. Hurtado vs. California, 110 U.S. 516, 1884, 36. Twining vs. New Jersey, 211 U.S. 78, 1908, 24 Cancer in the Constitution, that they are included in the conception of due process of law. Thus, the Twining decision held unequivocally that the 14th Amendment was not simply a shorthand summary of the Bill of Rights and that the Due Process Clause did not incorporate verbatim the first 8 amendments as restrictions upon state power. On the contrary, in the court's view then, 1908, the Due Process Clause of the 14th Amendment simply expresses a demand for standards of fair procedure which are not defined by the specifically enumerated guarantees of the Bill of Rights. This had been the logical conclusion of Hurtado v. California, supra, holding that indictment was not a necessary attribute of the fair trial demanded by the Due Process Clause of the 14th Amendment, and in Maxwell v. Dow, which held that a jury trial was not a necessary attribute of due process in state criminal courts. 37 The item at issue in the Twining case was the prohibition against double jeopardy which the Fifth Amendment enforces against federal prosecutions and which the decision ruled out as a required feature of the due process imposed upon the states by the 14th Amendment. The Supreme Court's ruling in the Twining decision held firm for more than 50 years. It had a narrow escape in 1947 when its authority was again respected in a 5-4 decision by the Supreme Court. 38 In his concurring opinion in that case, Justice Frankfurter said, the notion that the 14th Amendment was a covert way of imposing upon the states all the rules which it seemed important to 18th century statesmen to write into the federal amendments, was rejected by judges who were themselves witnesses of the process by which the 14th Amendment became part of the Constitution. Arguments that may now be adduced to prove that the first 8 amendments were concealed within the historic phrasing of the 14th Amendment were not unknown at the time of its adoption. A surer estimate of their bearing was possible for judges at the time than distorting distance is likely to vouchsafe today. Remarks of a particular proponent of the amendment, number 37. 176 U.S., 581, 1938, Adamson v. California, 332 U.S. 46. Cancer in the Constitution matter how influential, are not to be deemed part of the amendment. What was submitted for ratification was his proposal, not his speech, a construction of the Due Process Clause of the 14th Amendment, as a summary of the specific provisions of the Bill of Rights, would tear up by the roots much of the fabric of law in the several states. Decisions of this court do not have equal intrinsic authority. The Twining case shows the judicial process at its best. Comprehensive briefs and powerful arguments on both sides, followed by long deliberation, resulting in an opinion by Mr. Justice Moody which it once gained and has ever since retained recognition as one of the outstanding opinions in the history of the court. After enjoying unquestioned prestige for 40 years, the Twining case should not now be diluted, even unwittingly, either in its judicial philosophy or in its particulars. 25. 1964 Exit Twining. Enter the mythologizers with the new 14th Amendment and a long series of repetitious decisions. As Justice Frankfurter pointed out, the Supreme Court had unequivocally declared what the country had every right to expect henceforth to go unchallenged, namely, that the restrictions of the Bill of Rights and the 14th Amendment respectively were aimed in entirely different directions and that they would each follow their separated constitutional paths without any future danger of collision or convergence. Nevertheless, those who relax their vigilance in this comforting expectation reckon without the power and persistence of the mythologizers and their unrelenting champions on the Supreme Court itself, namely, Justices Black and Douglas. With all due respect to the distinguished men who have come to and gone from the Supreme Court during the past 40 years, I am personally convinced that only a few of these justices have suspected what the mythologizers were doing, through them, to the Constitution and the country. In spite of continuing dissents from Black and Douglas, the Twining decision held on firmly until 1964. Its fair state trial concept then finally gave way before their insistent demand for a literal infusion of the entire Bill of Rights into the Due Process Clause of the 4. Cancer in the Constitution 26th Amendment. 39. In practice, this now means that an indefinite stay of execution is available for every person convicted in a state criminal court, while the appeal of his case is taken from the highest court in his state to the Supreme Court of the United States. What Justice Frankfurter predicted would tear up by the roots much of the fabric of law in the several states, supra, has now taken place. 40. Unfortunately, our legal profession has said or done little or nothing to inform the American people of what the Supreme Court has thus been doing to frustrate the popular demand for a restoration of law and order to our country. In deference to the tender sensibilities of Supreme Court justices, bar associations have largely ignored the sound advice of the late Chief Justice Harlan F. Stone. When the courts deal, as ours do, with great public questions, the only protection against unwise decisions, and even judiciary usurpation, is careful scrutiny of their action and fearless calm meant upon it. 41 Fortunately, the same diffidence has not restrained our newspapers from telling it like it is. Justice William Brennan of the Supreme Court is offended because critics have accused the court of freeing guilty criminals on technicalities. He blames crime on social conditions and not on encouragement by the court. Yet consider a few of the court's decisions which have provoked the charge that the court has been engaged in the biggest jail delivery in history. A year ago, Senator John McClellan said that the effects of such decisions as Allery, 1957, a District of Columbia case, Escobedo, 1964, and Miranda, 1966, had weakened intolerably the force and effect of our criminal laws. He said that they had freed many dangerous criminals and were daily preventing the conviction of others who are guilty. He said the guilty are being turned loose on some alleged minor, or dubious technicality. 39. Malloy v. Hogan, 378 U.S. 1, 1964, 40. Thus, after almost 20 years of dissent from the court's refusal to adopt this conclusion, Justices Black and Douglas finally prevailed. The Constitution of the United States of America, Analysis and Interpretation prepared by the Legislative Reference Service, Library of Congress. 1952 and 1964 editions. Edward S. Corwin, editor, 1952, and Norman J. Small, editor, 1964, et seq. Page 1234, 41. See Hearings, Prayers and Public Schools and Other Matter, Committee on the Judiciary, United States Senate, July 26 and August 2, 1962, page 141. Cancer in the Constitution 27. Individual cases are here cited and described. Director J. Edgar Hoover of the FBI complained not long ago that there was undue concern for the rights of defendants while citizens could not walk the streets without being mugged, raped or murdered. That seems to put Justice Brennan's complaint in proper perspective. 42. Another example of the caustic criticism leveled at the permissive Supreme Court justices came from the San Diego, California, Union. The United States Supreme Court has returned 3 more decisions drastically altering the pattern of American life. For more than 15 years now, the court has been steadily rewriting the laws and reinterpreting the Constitution to suit the ideological bias or judicial whims of its members. In recent days, the Supreme Court has ridden over states' rights by abolishing residency requirements for relief, sidestepped a ruling in a case of burning the American flag, and placed further restrictions on law enforcement by freeing a convicted rapist because the police took his fingerprints in some legal hocus pocus. Court majorities, which in those 15 years have returned more than 30 decisions, have brought about basic and often demoralizing changes in the fields of politics, criminal procedure, religion, race relations, subversion and communism, antitrust laws and obscenity. The court has told the states how they are to portion their legislatures, granted avowed communists the run of defense plants, made a criminal's confession almost impossible to use, approved even secondary school demonstrations against the South Vietnam War, banned prayers or reading of the Bible in public classrooms, ruled that passports cannot be withheld from communists just because they are communists, and held that deserters from the armed forces even in wartime cannot be stripped of citizenship. In the notorious Keelishan case, a majority opinion held that a college professor may not be dismissed for teaching and advocating, in college or anywhere, the overthrow of our government by force and violence. The court, once the ultimate in both prudence and juris. 42. The Chicago Tribune, May 12, 1969. 28. Cancer in the Constitution. Prudence is now the darling of the liberal radicals. It has done for them what the Congress has refused to do. It has been the liberal radicals who have been advocating more participatory democracy. This means they want all science affecting the lives and fortunes of the people, no matter how trivial, thrown into the arena of public dispute. And the Supreme Court has been their strong supporter. The court consults nobody. It is beyond the reach of the people, and seemingly beyond the reach of their elected representatives in Congress. It decides as it pleases. 43. Communists now have a new constitutional right to teach in public schools. Note that the editorial is particularly critical of the court's unprecedented decision in the Keelishan case, which killed a New York state law that sought to prevent communists from holding administrative or teaching positions in New York public schools. In Adler versus the Board of Regents, 1952, the Supreme Court had upheld this very same New York statute in a decision read by Justice Minton. Said the Supreme Court in 1952, a teacher shapes the attitude of young minds toward the society in which they live. The state must preserve the integrity of the schools. It cannot be doubted that the school authorities have the right and duty to screen the teachers and employees as to their fitness to maintain the integrity of the schools as a part of ordered society. We know of no rule, constitutional or otherwise, that prevents the state when determining the fitness and loyalty of such persons from considering the organizations and persons with whom they associate. Speaking for the court in Keelishan et al., Supra, Justice Brennan overruled this 1952 decision for the reason that pertinent constitutional doctrines have since 1952 rejected the premises upon which that conclusion rested. The modern pertinent constitutional doctrines have been fabricated by the mythologizers. Said Brennan, dangers fatal to First Amendment freedoms, inhere in the word seditious. Academic freedom is a special concern of the First Amendment, which, 43. The San Diego Union, April 28, 1969, 44. 385 U.S., 629, 1967, in. Law in. Ve. 2. Michigan. Cancer in the Constitution. 29. Does not tolerate laws which cast a pall of orthodoxy over the classroom. The new constitutional principles of which Justice Brennan speaks have, as we have now seen, taken God out of the classroom and put communist teachers into them with permanent tenure. With reference to the Keelishan decision, the late Justice Michael A. Musmano of the Pennsylvania Supreme Court observed at the time, according to this reasoning, Benedict Arnold could not be dismissed from teaching at West Point. God and the government. During the continuation of their long fight to blanket the entire Bill of Rights into the Due Process Clause of the 14th Amendment, the mythologizers were making much faster progress in their single-barreled effort to identify the entire First Amendment literally with the 14th. They achieved this prized objective 23 years ago when 8 of the 9 1948 Supreme Court justices joined in the court's decision of the Vashti McCollum case. 45. I trace the development of this determined drive to merge the First Amendment lock, stock and barrel into the 14th, in the May, 1948, issue of the Notre Dame Lawyer. 46. It goes without the saying, of course, that everything decided in and pursuant to Twining versus New Jersey, Supra, establishing the complete separation of the first 8 amendments from the 14th, established the independence of the First Amendment at the same time, although the 4th, 5th, 6th and 8th amendments were the primary consideration of the Twining decision and those made pursue and to it. Nevertheless, right while the Twining rule was in control on the main line, the mythologizers were fiercely and successfully forging an inseparable homogenized linkage of the First and 14th Amendments on a side track where a hot succession of Jehovah's Witnesses cases was contesting the question of religious liberty, so as to avoid a labored repetition of what I found, reported and predicted elsewhere 23 years ago about the questionable forebears and inevitable offspring of Vashti McCollum, Supra, let us. 45. People of Illinois ex rel Vashti McCollum versus Board of Education, School, District No. 7, 69 SC 461, 1948, 46. The Notre Dame Lawyer, Volume 23, page 456. Cancer in the Constitution. 30. Go now to the end rather than the beginning of this tangled but stent drive to get God out of the government of the United States. Here then, is the cap on the fatal mythological climax. This court has decisively settled that the First Amendments mandate that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof has been made wholly applicable to the states by the 14th Amendment. Justice Clark led off with the foregoing declaration. In the Supreme Court's decision in the Shemp-Murray cases. 47. By this time, 1963, this flat declaration of Palpable error had become routine in Supreme Court decisions, and it has remained so ever since. The court no longer feels it necessary to document such a well-settled principle of the new mythological constitutional law. But, for the record, Justice Clark followed the expression with a list of 7 Supreme Court decisions, the implication being that the declaration had been the basis for the Supreme Court's decision in each of them. To the casual reviewer, these citations would seem prima facie to make the uncommon law marriage of the First and 14th Amendments respectable by age if for no other reason. But in these citations, Justice Clark made the mistake of stepping further back than Vashti McCullum, 1948, to include Murdoch versus Pennsylvania, which was decided in 1943. Let us, therefore, take a look at this 1943 decision, which is supposed to have started what is now the decisive settlement. Justice Douglas marries the First Amendment to the 14th. First of all, please observe that it was written by Justice Douglas. The case involved Jehovah's Witnesses petitioners who went from door to door in the city of Jeannette, Pennsylvania, distributing literature and soliciting people to buy Bible tracts and religious pamphlets, all in defiance of a 40-year-old city ordinance requiring a license for all such commercial canvassing. The witnesses refused to apply for the license and had proceeded to canvass without it. In 47. School District of Abington Township, Penn vs. Shemp and Murray vs. Curlett, 374 U.S. 203, 1963. M. Agus. Stin. Cancer in the Constitution 31. The beginning of his decision, Justice Douglas stated there, the petitioners' contention, namely, that the ordinance deprived these Jehovah's Witnesses of freedom of speech, press and religion. A bare majority of the court found from the facts that the ordinance had done just that. Thus, as we have seen, Justice Douglas had plenty of accumulated authority to support a conclusion that the Due Process Clause of the 14th Amendment had been violated by the city ordinance in question. No definition of liberty could or had been made by the Supreme Court, or by any other recognized authority, for that matter, which did not include religious liberty and the freedom of speech and or of the press. Back in 1925, for instance, the Supreme Court had said, for present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. 48. Then there was the concurring opinion of Justice Cardozo, in Hamilton versus the Regents 49 in 1934, in which he had said, I assume for present purposes that the religious liberty protected by the First Amendment against invasion by the nation is protected by the 14th Amendment against invasion by the states. This was all the authority that Justice Douglas needed in order to hold for the petitioners after the court's finding of the facts. And, unless the ordinance did so violate the liberty clause of the 14th Amendment, the complaining witnesses were hooked because their liberty was not protected against state action in any other place in the federal Constitution. But, on the contrary, Justice Douglas mentioned the 14th Amendment only once. He stated that the First Amendment, which the 14th makes applicable to the states, declares that Congress, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press, etc. had been violated. There. After and again, throughout his decision, Justice Douglas. 48. Gerlow versus New York, 268 U.S. 652, 49. Hamillion versus the Regents, 55 SC, 205. 32. Cancer in the Constitution, says it was the First Amendment that made the offensive ordinance unlawful. He never paused to cite any authority for his controlling opening declaration, namely, that the 14th Amendment had made the entire First Amendment applicable to the states. He cited no such authority for the good reason there was none. He reiterated that the First Amendment required the nullification of the involved ordinance. He thus used the First Amendment directly as a restraint upon state action and not simply analogously to the 14th, as had been done in the Gitlow and Adamson cases, supra. Why did Justice Douglas do this? And what difference did it make, since the complaining Jehovah's Witnesses would be just as free to continue the questioned practice of their religion in either case? Only Justice Douglas can tell us why, but the difference became obvious when Justice Black began to use this Douglas-Murdoch decision as his basic authority for holding that the states were prevented by the First Amendment, from setting up what he construed to be an establishment of religion, regardless of his own admission that no loss of freedom was involved in any of the so-called establishments. Everson versus the Board of Education, the New Jersey bus case. 330 U.S. 5, 1947. Vashti McCullum versus the Board of Education. Release time for religious instruction in public schools, 1948, supra. And Engel versus Vitale, New York School Prayer Case, 370 U.S. 421, 1962. And then comes Justice Clark and Shemp Murray, supra. 50. On May 4, 1970, Frederick, Waltz versus Tax Commissioners of New York, the Supreme Court suddenly and unexpectedly reversed its field on a critical question involving the relationship of church and state. The appellant, Waltz, sought to knock out New York's grant of property tax exemption for buildings used for religious worship, contending that the exemption violated the First Amendment's prohibition against the establishment of a religion. The political implications of a decision favoring the appellant were obvious. Prohibition of prayer in public schools was one thing, but a Supreme Court decision that would require all churches large and small to pay property taxes on their houses of worship to the several states in which they were located could be interpreted as a tax on prayer and would be certain to put the court in the middle of what could easily develop into a nationwide political revolution. Chief Justice Burger undoubtedly recognized this danger and was determined to avoid it by a unanimous decision, if possible. Eventually, he persuaded 8 justices to join him in a rambling opinion which concluded that state grants of tax exemption to churches were not a violation of the religious clauses of the First Amendment. Only Justice Douglas refused to be stampeded. His long dissenting opinion is, in substance, a frank verification of all that we have said herein about the sudden transformation of the 14th Amendment by its unlawful identification with the First. Cancer in the Constitution 33. Thus, for the 32 years of service together on the Supreme Court, Justices Black and Douglas have been repetitiously citing each other as authority for a gross and gratuitous misconstruction of the First and 14th Amendments. This misconstruction has now congealed into a fixed rule of law which, among other things, makes it impossible for our state-controlled or tax-supported educational institutions to take Douglas chides his errant brothers who turn tail in the Waltz case and to support a collateral point about the effect of taxation, he goes back to Murdoch versus Pennsylvania where single-handed, he had started the big ball rolling by gratuitously declaring the First Amendment to be a part of the 14th. Here, apparently Douglas becomes self-conscious about his sole responsibility for the revolutionary consequences he attributes to the first 14th merger and, for the first time anywhere to my knowledge, he attributes its origin to Justice Roberts' decision of Cantwell versus Connecticut, 310 U.S. 296, 1940. This late attribution is indeed significant because when Douglas made his own first-time anywhere declaration of the merger in the Murdoch case, 1943, he did not use Cantwell versus Connecticut, 1940, or any other case, to support his statement. Said Justice Roberts for the court in Cantwell, "We hold that the statute is construed and applied to Cantwell and his associates, deprives them of their liberty without due process of law in contravention of the 14th Amendment, sic." Then for himself, Justice Roberts went on to say that the liberty described in the 14th Amendment embraces the liberties described in the First Amendment. He then reiterated the obvious, namely, that the First Amendment keeps Congress from interfering with religious liberty. He elaborates on the effect of the First Amendment's restrictions upon Congress and winds up by reiterating that the 14th Amendment now prohibits the states from passing such laws. If he meant to include in such laws legislation respecting an establishment of religion, he didn't say so, and the entire statement is ended without any documentation of authority whatsoever. This is the language upon which Justice Douglas relies to say in dissenting to Waltz, the Free Exercise Clause of the First Amendment was expressly deemed incorporated, sic, into the 14th Amendment in 1940 in Cantwell versus Connecticut. Elsewhere in the same opinion, he says that the first direct holding as to the incorporation of the First Amendment into the 14th occurred in Stromberg v. California 283 U.S. 359. This was a free speech decision decided on the basis of the liberty guaranteed by the 14th Amendment. There is not one word in the decision indicating any incorporation of the First and 14th Amendments. The same is true of all the cases cited in this context by Justice Douglas in Waltz. He invariably interprets any reference in any decision, as in Gitlow, 268 U.S. 652, to the First Amendment's protection of free speech against Congress as an incorporation of the First Amendment into the 14th. Here in this dissenting opinion, Waltz, 1970, you find the full collection of Douglas authorities for concluding that no state may now make or enforce any law respecting an establishment of a religion, but not one of the cases holds what he says it does. Thus the ruling identification of the First and the 14th Amendments that has now ruthlessly secularized all the laws of all the states of the Union falls back upon Murdoch and the unaccountable presumption of Justice William O. Douglas. Cancer in the Constitution. 34. Any official cognizance of Almighty God or to do anything else to implement the first basic self-evident truth of our Declaration of Independence. Before Justice Black's debut as our official American historian, it was a generally accepted fact that the First Amendment's prohibition against the congressional establishment of a national religion was to protect the reserved right of the several states to maintain their own religious establishments without interference by or competition from the new national government. 5 of the 13 original states had official state churches firmly established by law at the time the federal constitution was adopted. Justice Brennan has taken cognizance of the possible flaw in Justice Black's historical interpretation of the Establishment Clause, but only with fatalistic resignation. He admits that it may be true that the danger of a new nationally established religion was what worried the framers of the First Amendment, but then even if we assume that the draftsmen of the 14th Amendment saw no immediate connection between its protections against state action infringing personal liberty and the guarantees of the First Amendment, it is certainly too late in the day to suggest that their inattention to the question dilutes the force of these constitutional guarantees in their application to the states. 52. This would seem to be another way of saying that the Supreme Court's own statute of limitations has now run against the meaning and intention of those who framed and adopted the First and or the 14th Amendment, so henceforth, we must simply grin and bear the meaning and intention of each that has been substituted by imaginative history compiled by Justice Black and made official by his compliant associate justices on the Supreme Court of the United States. 53. 51. For our official recognition of God, prior to the prayer decisions, see The Supreme Court and Public Prayer, by Charles E. Rice, Fordham University Press, $5. 52. Shemp Murray et al. Versus Curlett, 374 U.S. 257, 53. Speaking in a tribute to Justice Black at the time of the latter's death, President Nixon said, among other things, that the deceased justice had left an indelible mark on the Supreme Court. That is true, certainly, but the president might well have said too that Justice Black had left an indelible mark on the Constitution of the United States, which his successor, however strictly he attempts to construe the Constitution, will never be able to erase. Cancer in the Constitution. Our constitutional system is seriously sick. 35. The accumulation of these malignant constitutional misconstructions of the first 8 amendments with the 14th has placed a cancer near the heart of our constitutional system, which has proliferated with each successive term of the United States Supreme Court. The cancer grows unchallenged and apparently undetected by lawyers representing both sides of the involved controversies, in spite of the fact that it has already drastically malformed the federal nature of our Republican government. Although the court is now firmly fixed in its baseless conviction that no state may directly or indirectly establish a religion, the justices appear to be ever more sharply divided on what are the necessary constituents of such a prohibited establishment in particular cases that continue to come before it. A new stream of appeals is already in motion toward the court concerning the extent to which state aid may be extended to private schools. Chief Justice Berger estimated the weight of this new judicial burden when he decided that henceforth it will be the court's job to determine in and for each case whether the proposed mix of religious and secular purposes is consistent with the court's conception of what is not an establishment. 54. The court thus joins this added right and duty to what, in the repeated public statements of Chief Justice Berger, is a constantly increasing burden of pending cases which is seriously impairing the quality of the court's work. It would take a number of constitutional amendments, each very carefully drawn, and a clear, continuing, conservative majority of the Supreme Court for the next 20 years, neither of which we have any reasonable right to expect, to put the Constitution of the United States back into the context where Justice Black discovered it at the time of his appointment in 1937. The mythological reconstruction of the 14th Amendment, which was superintended by Justices Black and Douglas during the past 31 years, has paralyzed the Constitution's carefully structured operation of our government as a federal system. In the process, the Supreme Court has been devouring the constitutional integrity of the states and rewriting congressional legislation to suit its own conception of what Congress intended. If it is to survive, the Constitution itself must have a breathing spell disentangled from the rank growth of recent Supreme Court decisions that have projected federal court jurisdiction into areas of power that belong to other constituents of our constitutional system. The Constitution provides its own corrective for this judicial usurpation in its section the 2nd of Article 3, where Congress is given the power and the responsibility to put the federal courts back into their proper place. 54. Lemon et al. Versus Kurtzman et al., June 28, 1971. Cancer in the Constitution. 36. The Supreme Court's docket is dangerously overloaded. All of Justice Burger's frequent pleas for the Reformation and expedition of our presently slow-moving administration of justice invariably end with the recommendation that the constantly increasing number of cases being appealed to the Supreme Court be reduced. For instance, in his second annual, 1971, State of the Judiciary address to the American Bar Association, the Chief Justice noted that the 9 justices now deal with about 4,000 appeals each year, sharply higher than the 1,100 of 1940 or the 1,300 of 1950. Either the quantity or the quality of the work of the Supreme Court must soon yield to the realities, he said. 55. In an interview with the New York Times, July 4, 1971, Chief Justice Burger was asked, what can be done to make federal appeals faster? He replied, well, the first thing is to have fewer of them. But Congress has made the decisions, which they have a right to do under the Constitution, making virtually every criminal case in the federal system subject to an appeal at government expense with a lawyer furnished, all of these expenses of the appeal supplied without regard to whether it is meritorious or utterly frivolous. Thus, in unmistakable language, the Chief Justice is asking Congress to relieve the court of its burgeoning caseload or suffer the public to take the consequences in an ever-increasing slowdown in the administration of justice, plus a constant deterioration in the quality of the Supreme Court's decisions. As the Chief Justice says, only Congress can resolve this crisis. The court no longer has the will to shrink its docket of appealed cases by exercising the kind of judicial restraint that Justice Frankfurter called for in vain in his dissent in Baker v. Carr, Supra. On the contrary, the present court is constantly reaching for more jurisdiction rather than less. The only hope for the survival of our constitutional system lies in the prospect of an awakened constitutional consciousness in the Congress of the United States, to be followed by the bold and decisive use of congressional power under Article 3, Section 2 of the Constitution. Congress can and must restore the vitality of its own legislative power and at the same time revive the constitutional integrity and 55. Wall Street Journal, July 6, 1971. Al. Nahi fly. C. Atlee. D. Ativant. Cancer in the Constitution. 37. Responsibility of the states of the Union by stripping the Supreme Court of the jurisdiction it has assumed to hear, decide and to thereafter take over the administration and management of matters that belong to the Congress, to the states respectively and / or to the people by the express direction of the Constitution itself. The responsible voice of the American people cries out now for a. the restored safety of our streets, b. the suppression of treason, anarchy and destructive revolutionary violence, c. the restoration of decency in publication and public exhibitions, d. the revival of respect for religion and moral order in our presently deranged and senselessly secularized state educational system. E. the sudden end of compulsory busing of children for the purpose of achieving racial balance in public school classrooms. All of these and other related objectives, reforms, revivals and restorations can be accomplished by the constitutional powers of the several states when these powers are freed from the gratuitous assumption of federal court jurisdiction. What is needed is a prompt and systematic shrinkage in the appellate jurisdiction of the Supreme Court of the United States and a complementary restriction of the jurisdiction of all of the federal courts in the country. I regret to say that many of our United States representatives and senators doubt their ability so to restrict, control and or abolish selected categories of the Supreme Court's appellate jurisdiction, and that many of them sincerely believe that the Supreme Court would simply hold such measures unconstitutional if and when they are passed. One of the important purposes of this paper is to provide all of our senators and congressmen with authoritative assurances that their power in the premises is unlimited. Every United States senator and representative has immediate access to what is called the analysis and interpretation of the Constitution of the United States. This study was prepared at the direction of Congress itself by the Legislative Ref. 56. See Note 18, Supra, page 13. 38. Cancer in the Constitution. Errant service of the Library of Congress for the personal use and information of every member of Congress. The original editor of this magnificent work was my learned and esteemed colleague, the late Edward S. Corwin of Princeton University, who once said, "The question arises, how far a court is entitled to indulge in bad history and bad logic without having its good faith challenged?" If he were alive today, I am sure that he would add, and without having its jurisdictional teeth pulled. I am immeasurably grateful to my distinguished friend, Dr. Charles E. Rice, for his informative and helpful introduction to this paper. It is upon the patriotism and scholarship of dedicated authors and teachers such as Dr. Rice that the continuity of our constitutional freedom ultimately depends. May God bless and prosper all of them. Clarence E. Manioun, Dean, Emeritus, College of Law, University of Notre Dame.